So we have seen that recently the whole legal system, especially in criminal law, has been redrafted and recrafted with a new vision. The vision is very clear and everybody can endorse that view. Why government is coming up with a new law? Because as a student of law, we know that state has certain functions, and the basic function is waging war and protecting against a war. Then the second most important function of the state is administration of justice. And when it comes to justice, the correctional justice is very important because the concept of harm, the concept of wrongdoing, punishing the criminals by the penal law is very important. And the idea of punishment with the royal scepter has been deeply ingrained in every society. So, penal laws are punitive order of the state is an epitome of sovereignty of state. And any state which is having a colonial law will be intrigued to make a new law because it creates a history. And that was the opportunity with our own government, which did not miss the opportunity, rather changed all the laws. The Indian Evidence Act, Indian Penal Code, the Code of Criminal Procedure, they all were replaced by new laws. And the new law which I am going to discuss with you is Bharatiya Sakshya Adhiniyam. BSA, as we are seeing now in the new act, is in alignment of the main law, which is Bharatiya Nyaya Sanhita, and BNSS, Bharatiya Nagarik Suraksha Sanhita. But what is very unique to BSA, we understand that in BSA is an adjective law. We call it like that in our legal studies because we classify law into two categories, the civil and criminal. The part of civil law which is meant for the public governance is bigger, much larger compared to the criminal law. But criminal law, as I told you, is an epitome of the power of the government, wherein the royal scepter is used for inflicting punishment. And in criminal law, there are four elements, as we know. There is a political sovereign declaring something crime. What is crime is known to the public in very specific terms. That's why you need to define it. And that's why the Indian Penal Code or the Bharatiya Nyaya Sanhita both are defining specifically what is crime and then providing punishment for that. And punishment is inflicted upon anyone irrespective of caste, creed, and color. That has been the scheme of lawmaking process in human civilization right from the era of codification, Hammurabi or Manusmriti or whatever code, Roman table 12, we have made it out. As I told you, Bharatiya Sakshya Adhiniyam stands for both, for civil law and for criminal law. Civil law basically is meant for two things, which is having subsets also. One is marriage, the other is contract, the third will be tort. In criminal law, we know that proof is very important because we have very certain fundamental principle about burden of proof. The state is the prosecuting agency, state is mightful, and the perpetrator or offender is single isolated individual having less power compared to state. So all the guarantees that we have given to the accused in Article 20 for the protection of the accused in criminal administration has to be taken care of. That is presumption of innocence, doctrine against double jeopardy, and protection against self-incrimination, which is very essential to any criminal adjudication process. Bharatiya Sakshya Adhiniyam is very unique. And as we see now that Bharatiya Sakshya Adhiniyam is redrafted, recrafted. And in this redrafting, we are seeing that there has been not much changes incorporated, but the law has been very technocentric. Obviously, because post 2000, our tryst with the computer technology, the ICT, has been fairly very advantageous, and Indians have really done very great in IT sector. Be it as a service provider, be it as a creator, be it as a software developer, we have gained a lot. And the kind of expertise that we have developed in investigation process, in collection of evidences, in making conclusive evidences which can zero in that who was the perpetrator, or even for proving rights, interest of the parties in a contested case in civil governance. So proofs are very important, and evidentiary value that is created by oral and documentary evidences has always been part and parcel of the adversarial process that we follow, the Indian system follows. In Anglo-Saxon system, the matter is contested by the parties, advocated, pleaded by the parties with the proof. And the burden of proof that we have designed in criminal law and civil law is very unique, because in criminal law, as we know, state is the prosecuting agency and state has to prove 100% beyond any reasonable doubt. That is the way we have made out. In civil governance, it is preponderance of probability. So case depends upon the level of proof adduced by the plaintiff. And if his level of proof is relatively better and conclusive compared to the defendant, he wins the case. So that is the way we have designed. So preponderance of probability and beyond all reasonable doubt, these are two pillar principles of administration of justice that we follow in the BSA. Bharatiya Sakshya Adhiniyam, as I told you, is a very unique law. It has been made with an intent that technology these days can do a lot to prove the claims of individuals or to prove that the offender committed the crime in totality. So we have brought out certain changes which was meant for making a new and sleek law. When we make a new law, there are many purposes for making new laws. I told you, we wanted to make a very indelible imprint upon the minds of Indians that we are governed by criminal law, governed by a colonial criminal law. So this is the high time we need to change. And as I told you, any government would like to change the penal law because punishing criminals is an epitome of justice. So the new act that has been created in BSA, it has 4 parts and 170 sections. Earlier there was 167 sections, but there were many amendments. And most of the amendments were made by Mrs. Gandhi to deal with the offenses of legitimacy of child, illegitimacy, dowry death, or alike. So this new law, which has been created, it is having 12 chapters, 4 parts, and 170 sections. Then the law of evidence mostly has traveled from the physical evidences to digital evidences. We know that the pattern of crime, the way crime is being committed, the way crime is getting designed, the involvement of accessories, the way recce's are being done, that involve so many technologies these days. And that's why the same technology like surveillance, CCTV footage, the chattings and messages shared by the perpetrators can be a very important piece of evidence for proving a crime. That's why electronic and digital evidences has been incorporated duly in the Bharatiya Sakshya Adhiniyam. Bharatiya Sakshya Adhiniyam is very much important because the way we are creating documents these days, mostly it involved processes wherein digital evidences or digital devices are being used. Almost everything that humans are doing is getting recorded. And we have, as a student of law, sometimes very unfair notion of document. The document is only piece of paper. But the definition that was there of document in the Indian Evidence Act, in the older law or the Indian Penal Code, that was very quite simple. And even if you take that definition in account even now, so digital evidences very clearly can be included in the definition of document. So it defines like that document is something which is an expression upon any substance in any medium. Expression, substance, and medium, these are three words which are very important to define document. So if your medium is EDI, electronic data interchange, what we call is something which is created by the use of ICT, information and communication technology, with the help of computer, with the help of mobile phones or digital devices, then everything is a digital document. So we very comprehensively defined the word document in the act itself. And therein, the memory cards, the pen drives that you are using, semiconductor integrated circuit technology that you are using for storing, transmitting, publishing any documentary proof, that has been included in the definition of document. And all the colonial imprints have been deleted from the act, which was mentioning like Parliament of UK, Provincial Act, London Gazette, Jury, Lahore, Her Majesty. These words have been totally deleted from so many places which were earlier mentioned in the Indian Evidence Act. Likewise, the expression vakil, pleader, barrister, which were many categories of advocate prevailing before Advocate Act 1961, has been substituted by advocate right now. The one thing that is again very important, the application of Indian Evidence Act. The proceedings which were run in army tribunals, they were not governed by the Indian Evidence Act. And the Indian Evidence Act equally did not apply to arbitration. It did not apply to the affidavit. But if you see the new act very clearly says that it applies to the court-martial proceedings or army proceedings, but it again exempts that it will not be applicable to arbitrator or arbitral proceedings or affidavit. So it maintains the older route, excluding one thing, that court-martial proceedings will be run based upon the Bharatiya Sakshya Adhiniyam. Then second definition, which I told you, document has been defined to include electronic and digital records. And after that, the digital records mostly is documentary, and documentary proofs are very important for proving civil cases. Because as in classes, we tell mostly that crime is basically a part of two very important things, actus reus mens rea, because that is based upon very fundamental cardinal principle, actus non facitrium nisi mens sit rea. So act or omission, that is willed muscular movement, which basically is contraction and dilation of your muscles. then that has certain state of affairs, because there will be doer, primary level, secondary level, abater, conspirators who will be coming together doing certain things. So every act that they are doing, that must be some criminal act creating some impact. And as we know that the IPC older was based upon cause and impact or cause and effect theory, which is basically a theory of causation, that you do something which results in something and that causes some loss to person or property. And if that is punishable in the major criminal law, then the punishment will be given to you after due trial. That is the way we have designed our criminal law. So mostly, if you see, injury to person involves lesser documentary evidences compared to oral evidences. And we have a best evidence rule, which is again very important, that primary and direct evidences must be given. If documentary evidences are available, orals will be excluded. These are very cardinal principles of the Evidence Act, which goes ditto in this subject. But digital records that are being created day in, day out these days plays a very cardinal role. And especially after Arjun Pandit Rao case, that records which are being created by digital devices, if they are being created on the digital devices itself, and if they are being created with the help of internet, like you are clicking a photo simply by a mobile phone which is not having at all any IT services or telecom services, like a phone with no SIM cards, you are clicking a photo which is not having any kind of Gmail login, then the photo is stored on the device itself. But if you are clicking a photo which is having a SIM service, the device, and equally you have logged in your Gmail account, then the photo is equally getting stored on Google Photos. That happens all the time, even if we are not knowing it. So Arjun Pandit Rao or the older Act, Section 65A, 65B had some requirement of certification. So if something is lost on your network, it does need a certification from the service providing authority. But if something is there on your simply device, it does not need any kind of certification. But certification requirement is there that the way evidence has been collected, it is maintaining the intactness of the evidence, and there has not been any kind of concoctions or fabrication or doctoring with the evidences. Mostly when a viral message is viral, or on the basis of that any kind of crime is reported, the perpetrator says that this is fabricated. So this kind of situation is to be averted. That's why the certification is required. In the new act that we have designed, there is a schedule which talks about that when evidences of such nature are being collected, then certification from the person who has collected, appreciated the evidence is required from the person, and he has to certify this, that what methodology was used for keeping, appreciating, collecting the evidence. And if you see the schedule, there are 3 technologies which are identified: systematic hashtag algorithm 256, systematic hashtag algorithm 1, and message digest MD5. So these are 3 technologies, and out of these 3, the best way is 256, systematic hashtag technology 256. This basically ensures that when a police impounds any digital device, collects it, and it goes for FSL lab analysis, and it comes as a report to the trial judge for adjudication, then in this whole process, there is no chance of fabrication of the evidence. And that is ensured by the systematic hashtag algorithm 256. The certification is important, which is provided in the act itself. So this is something very important. And the way we have designed our new act, because in the new act, if you see, if the offenses are punishable in the severity of the offenses with higher punishment, the use of FSL technology or forensic science labs technologies is a must. So collection of evidences depends mostly upon the proofs, like you are taking genetic material from the scene of crime, collecting pieces of evidences, you are uh, collecting evidences from computers which are running conditions, you are collecting hard drive, maybe a solid state drive in a running positions, then collection of these evidences requires an acumen which normal investigator does not have. For that, you need a lot of instruments also for collecting it, because collecting data these days will not be possible, because we are not aware about these things, that internet services which are being run, there is a lot of things which are done in darknet services. And there is a lot of thing which is done basically on crypto technologies, like there is a lot of things which are being done on blockchain technologies, generative artificial intelligence, LLM models, which we are known about. So we need a lot of expert people who can collect all those evidences, and you need to create the intactness of the evidences in the whole process of collection, proving, and making a report about it, that what sort of evidences you have collected. Because proving everything against the accused, especially with that principle that one innocent will not be punished and penalized even if 100 accused go free. So presumption of innocence, despite of the fact we have diluted a lot, the doctrine against double jeopardy, the doctrine against self-incrimination, which is very diluted post Selvi case, is again a reminder to us that we should not make a law which is very draconian, which is very against the principle of fairness, which has been the achievement of Menka judgment. Because the kind of impact Menka judgment created upon the criminal administration, that is something which we should not forget about. So this act is making a very wonderful progression in that sense, that digital evidences has been defined. The definition of primary evidence has been enlarged to include these kinds of evidences. The definition of expert has been expanded. The colonial imprints have been deleted. Then res gesti, which is again very important part, section 6 to 39 of the older act and the newer act, which talks about section 4 basically onwards. It has made it applicable that now fact in issue and relevant fact both will be applicable or applied to res gesti doctrine. Earlier, it was only limited to fact in issue. So relevancy again is part and parcel of that. And this basically enlarges the whole idea that relevant fact can also be part and parcel of the res gesti principle. The principle of confession, especially which was in the older act, section 24, wherein if the confession is given under the inducement, threat, or promise, then when it is gone, it will be admissible piece of evidence. And it now includes one more thing, which is called coercion. So coercion has been included in the definition of that. Then after confession, in the confession chapter itself, there has been one more thing, that where more than one person are party to the crime, because we know that these days the syndicate crimes are very popular. The transnational crimes which are basically run, they are very popular, like digital arrest. We see how digital arrests are being done. I can just give you an example that Indian mostly the Indian youths are being hired by the people who are based somewhere in foreign, maybe the Cambodia as a country, and they are hiring Indian peoples who are posing themselves as the person or personnel from the law enforcement agencies, and they are just arresting someone in the threat of the abuse of the PMLA or the custom or the other acts. And when they are giving money to them, the money is being converted into crypto money, and the money is being sent 70% out of the country in the crypto form to the any person who is just handling all these youths as excuses, and the money is just going out of the country. So bringing that money back, making them accountable is next to impossible, because they are operating from darknet. That is something very, very difficult for Indian government to do so. So only thing is, so long the Indian people are involved, the Indian mules basically are involved, they can be traced easily. But tracing those people who are operating in darknet with the use of blockchain technology or artificial intelligence is next to impossible these days, and you need a lot of expert or expertise from these kinds of sectors. That's why Section 24 again is talking about that if somebody is being tried in absentia, because mostly the people who have been the part of syndicate crime, they will be not totally in Indian subcontinent. So those parties who have been the Indian parties, they are being jointly tried. Then the confession of the accused can be used against the persons who are being tried in absentia. This is something new which has been made in the new act. Gazette again is very important. Electronic gazette has been made admissible. Electronic records, electronic books, electronic journals, they have been made admissible as a piece of evidence. Then final judgment, order, decree of tribunal has been made relevant, and it is a piece of evidence, good piece of evidence. The definition of expert has been expanded, and the expansion now includes that an expert of any other field, because you know the way technology is changing, the pace is very fast. So in this fast paced change of the technology, you need to create inclusive field wherein the person who is an expert of any other field can come and testify that what kind of evidences need to be proved before the court of law, because experts are basically those people who are working as an ancillary to the system, and they will be coming supporting the system to prove a point. After that, as we go on, the definition of primary evidence has been expanded, and it was there in the way of interpretation that if you make multiple copies in a mechanical way, that all will be primary evidence, but that has been included in the part of definition. Digital electronic record created, stored in multiple files will be a primary evidence, because you know that you collect a lot of the way things are multiplied in the modern technology, especially in the use of EDI and ICT. Everything is a primary document, and it can be proved in the court of law, because primary and direct evidences are reduced in the court of law. That is the rule of the law. And the second thing, as I told you, that when orals are available, when document is available, then orals are excluded. And secondary evidences are allowed when primary is not available. So we know everything, and this has been very duly incorporated in the Bharatiya Sakshya Adhiniyam. After that, the next change that we see, which is in the Bharatiya Sakshya Adhiniyam, is about the examiner of electronic evidence. So their piece of advice, their piece of evidences, again, is opinion, and that opinion does matter as an opinion of expert. That's why I told you that we have expanded the definition of expert, that he may be an expert of any other field, because the examiner of especially electronic records, that whether the records are correct or not, because he in the process will be collecting it in the FSL part, and he will be telling you only that whether the information provided in the device is not an information which is concocted, and whether the device is the only storage device or it has been transmitted to other devices also or not. So that has been included in the definition. Now moving on, section 122 of the BSA is again very important because it creates a small change, and the change is that in tenancy we often see that the tenants after creation of tenancy takes a plea that the landlord is no more owner of the property. That is called denial of title in the property law. So it creates a lot of problem in the evidentiary value or evidencing about the tenancy conflict. So this is very clearly mentioning that if there is a tenant and tenancy has been there in a legal way, then after continuance of tenancy, any time thereafter, the tenant will not be permitted to take the plea that he is not tenant, rather landlord of the house. So this is something very new and is incorporated in BSA to avoid all the problems which is made in tenancy law. And tenancy law is really very intriguing subject. So model tenancy law in UP is aligned with this law, and all other tenancy laws which are being made now, they are also recommending the same, that anytime the person who is tenant takes this plea, then again there are certain changes which BSA is talking about, and those changes basically is about privileged communication and the cabinet communications and the communications made by the president to the ministers. That has been again excluded by section 165. So when we see the totality of the provisions contained in the Bharatiya Sakshya Adhiniyam, we see that there is a lot of thrust being made upon the electronic evidences, and that is well appreciated because these days the electronic ecosystem that we have created in our life is creating a kind of conclusive evidence to prove crime and to prove civil rights. That's why the evidentiary value in the electronic records have been identified and has been implemented in the Bharatiya Sakshya Adhiniyam. So in short, this is the changes that we have brought by the Bharatiya Sakshya Adhiniyam. Challenges before the administration is very high because right now there are 7 FSL, Forensic Science Laboratory, and there are 30 plus state FSL. So far, so state FSL is concerned, I can tell you that many states do not have very functional FSL, which is having all the facilities, wherein all the new technologies like DNA profiling, the brain mapping, the lie detector test, or the genetic analysis test, or even the understanding of the blockchain technology or generative artificial intelligence or LLM, or integration of all these technologies, crypto analysis is not available right now. And we don't have that required number of experts also in this area. But at some level, the start and beginning has to be done. And that's why Government of India is opening a lot of universities like NFSU, National Forensic Science University, and they are opening all state wings. And I am really hopeful that in days to come, there will be sufficient number of people who are expert in collection of evidences, which will be electronic evidences, and electronic evidences will be used in a very conclusive way to prove a particular point, and that will help in dispensation of justice. With these words, I'm coming to end of my lecture. If you have any questions, you may ask.